That way we can kind of get to know you or you and your spouse. We schedule those again for 2 hours. You'll meet with an attorney from our office. We can meet Appleton, Green Bay, Oshkosh, whatever works best for you. We use the 2 hours to figure out what it is maybe that you'd like to do with your goals, with your planning. Typically by the end of that, the attorney is able to recommend what it is that you should do and quote any of those prices. So if you'd like to attend that initial consult, we will be sending you out some materials after the end of this. They'll be emailed. You can always fill out on that form if you would like us to contact you to get an initial consultation scheduled. You can always reach out to us as well. We have a couple of events coming up focusing on other topics, so some excellent education options there too. To get started, one of the biggest things that I want to focus on is a handout that you'll be receiving talking about estate planning myths and what it is that you can really do with your plan to help make everything easier on your family, which is a big goal often of why people do planning. The first thing though, is I always want to make sure that you have that plan in place for if you become disabled, incapacitated, or pass away. So yes, a really big part of estate planning is what happens with your estate, which is just literally what you own when you pass. But you have to make sure that you or you and your spouse have what you need during your lifetimes. So we always just identify that there are 4 documents that everyone should have. And what these 4 documents are intended to do are to make sure that you or you and your spouse have someone that can step in for you during your lifetime if you become disabled or incapacitated, for financial things, for medical things. So those 4 documents are a financial power of attorney, a healthcare power of attorney, a HIPAA authorization, and a living will. And these 4 are so essential because if you were to become disabled or incapacitated, the law doesn't assume that someone is able to help make your healthcare or financial decisions. And sometimes individuals who don't have any planning in place for this can have to go through what's called guardianship. So guardianship is a court procedure that we'll actually be talking about in more detail 2 weeks from now at our webinar. So if you'd like to learn a little bit more about guardianship and how to avoid it, you can. But what we want to make sure is that the people that you trust have the legal authorities to do whatever it is you kind of need them to do at that point. Trust is very important. It matters that you trust the people that you're naming. And it's also really important to understand what it is that person can do for you. Because sometimes people think that it's kind of a false sense of security, that all powers of attorney are created equal. And what really matters is the authorities within that document. So if I'm looking at a healthcare power of attorney or a financial power of attorney, I need to look through and say, okay, what specifically can this person do? The effect that you want to achieve is something saying, well, whatever they need to, because I trust this person to take care of me and kind of do the right thing. But you need to specifically have lots of different authorities on there to make sure that they can handle whatever that is. Especially when we're talking about care. If you were to need care and we're trying to do any ability to preserve some of what you have for you or you and a spouse, make sure that you're receiving that, good quality care. We have to know that we have those relevant authorities within that document. Otherwise, if that document doesn't say anything, what happens with your family is they may have to go to court for those additional authorities. And we want them to have everything that they need. So that way, perhaps that court process, totally unnecessary for them. It's going to make it a lot easier. It's going to keep everything more private. It's going to be overall less expensive than going through guardianship or really kind of any court process there would. With powers of attorney, and I'll just say again, if you have questions, you can put them right in chat. But with powers of attorney, especially medical powers of attorney, one of the biggest things you can do to help alleviate stress or that decision-making kind of fatigue is to have good conversations with the people that you're naming in these documents about your healthcare decisions. Because ultimately, it would be nice if your family's not really feeling like they're truly deciding, they're communicating what you've already decided about your care. So this could be just, I know these conversations are hard, but they're important. talk through what it is that's important to you. If you have any spiritual or religious requirements, especially around end of life decisions. So maybe things that you've seen or would be important to you. That way your power of attorney knows if you're in that situation, this is what you would want. Now that power of attorney, that healthcare power of attorney, may be the person who's called upon to help make end of life decisions. So you want to know, A, is that person going to follow through with what I want? Are they going to be able to do that emotionally? Because that can be a very difficult thing for some people. Some kids will say, no, I can't do that. Like, I love you and I understand that that's your wishes, but I could never like pull the plug, so to speak. So you don't want like someone like that on your healthcare power of attorney if that's your wish. So it's really important that you have good conversations about your end of life wishes, about your medical decisions. So that way that stress can really be alleviated from your family in an emergency situation. And the powers of attorney documents are the tools that your family has to make that decision, keep it, a little bit more private outside of that court involvement. Because otherwise, if you don't have those things, that can necessitate that guardianship process. So to keep it, again, kind of minimizing stress on your family in that situation, a part of your estate plan is planning for that disability or incapacity. So I haven't seen any questions yet, and that's fine. Moving away for a little bit as to, making sure that you and your spouse have what you need. Again, that's really done through those 4 documents that I mentioned. Obviously, estate planning is also what happens when you pass away. So often people think that the biggest thing in estate planning is how much money you have. That's the biggest factor in what you do. And that's just not true. It can be an important factor. Like if you have a taxable estate, which is a really, really high value of your overall estate. Right now it's 12.92 million each. So, for married spouses, you double that. Can certainly be a factor, but I don't have that problem. Less than 0.1% of the population, I believe, has that problem. So typically what we're focusing on is less on that size of your estate. It's more on, other kind of regular taxes, capital gains, income, but it's more about the individuals that you're planning for and what their needs are. Your family, if maybe you're trying to protect someone from something like a divorce or perhaps a bad spouse or partner, wanting to maintain some of that protection. If they have creditor concerns, bankruptcy concerns, care concerns, so on means tested benefits, it's really important that your attorney be aware of that, so that way they can properly plan for that and how you leave assets to somebody to make sure that you're not causing harm to them or potentially disrupting any benefits there. Able to set up some protections is really important in planning for those people as individuals. Another really common question that I get is related to probate. So probate is a really common thing that people are worried about with estate planning. And probate's not a bad process. It's not. It's just, it's a process. It takes a little bit of time. So probate does typically take your estate about 1 year to 1.5 years, start to finish to complete. You are going to be looking more at like a 3 to 5% administrative fee. Totally depends on how your attorney bills, how complicated your estate is. If you involved an attorney, there's still some court fees. And then it's public. So sometimes people have had bad experiences with probate, and their focus with their estate plan is trying to eliminate the need to go through that process. And one of the most common things I hear is that, well, I have a will or a pour over will, so my kids don't have to go through the probate process. I have that planning. And wills don't avoid the probate process. They are kind of simply define a set of directions to the probate court about what it is you want to have happen with your estate. So if you have a will, you're not avoiding probate. You actually want to use probate, which again is not a bad thing, but be aware that it takes a little bit of time. You have that kind of fee there just to be aware of. And what you really want is to determine, are you wanting to use a process like probate? So are you wanting to have that will and have everything funnel through that process, which again is fine. There are definitely some reasons to use that. Or are you wanting to make sure that maybe things pass outside of probate? Because sometimes when families are thinking about alleviating that stress for the people that, they're beneficiaries, one of the common things is to avoid probate. And the best way to really kind of avoid probate and still have good planning is through a trust. So when I say good planning, there are reasons or ways to avoid probate using beneficiary designations and other things. But those are ultimately a tool that's meant to be used in coordination with your plan. What you need to have with your estate is sort of the concept of a funnel. And your funnel is either going to be your will or your trust. You want to make sure that everything that you have is coming together. That way you have money to pay bills, final expenses, your taxes for that year, all those good things. And then it's going out according to your wishes with perhaps like that protection for others, or at least that triggering protection in case something has happened that you didn't see coming, like a disability or a substance abuse or someone's underage. All the planning that you actually create with your plan is contained in that will or in that trust. And if you pass everything outside of it, then you never really had that, kind of that plan there. So again, beneficiary designations are a tool. You'll have, obviously some problems with bill paying or other things. That's why you really want to make sure, what tool are you using? Are you wanting to use the will of the probate process? You wanting to have a trust or kind of an outside thing? So I think I see my first question. What is a safe harbor trust? So are you asking like for safe harbor for like the individual who's doing the planning, like trying to set up some like creditor protection for yourself, or trying to create like ongoing protection for a beneficiary? Because some states offer different types of trusts that can allow, not sure, just heard of it. That's fine. So a safe harbor trust is normally kind of referred to as a type of Medicaid trust. It's very similar to ultimately what we kind of use called a testamentary supplemental needs trust. It's very simple for what you're kind of trying to create some protection for a spouse who's on like Medicaid or other benefits. So we don't call that a safe harbor trust. I'm sure it might be called that in other states, but if the goal is to try to protect some assets for a spouse who's receiving benefits, we use a name called the Testamentary Supplemental Needs Trust, kind of an acronym of TSNT. I can explain more about how that Medicaid protection works if you like to. Essentially what it is when someone's on Medicaid, or when someone's on Medicaid and their spouse is living at home, that spouse who's at home is allowed to keep certain things. So like their retirement account, and it's up to like $148,000. And there's lots of calculations and other things in here too. But the idea is that this person can have certain stuff, right? As long as they're alive, they can have it. The problem is sometimes that spouse who's at home passes away before the spouse who's receiving care and on Medicaid. So if that healthy spouse passes away and leaves what they are allowed to have to that spouse who's in a facility, then and on Medicaid, that institutionalized spouse, the spouse who's in care, is going to lose their benefits because they're only allowed to have $2,000. So if you kind of get smart and say, okay, well, I don't want my spouse who's on Medicaid to lose benefits, so I'm going to go ahead and leave what I had to somebody else, like my kids, your spouse also loses benefits because that's considered a disinheritance by death. So what I think that safe harbor trust is talking about is what we use with those TSNTs. It's the only way that Medicaid allows you to kind of instantly protect that money from that Medicaid spend down. So that way that spouse is left those assets to support them above and beyond what Medicaid allows them to have. There's certain income shifts there, but it's not all then subject to that $2,000 spend down. So I know it's Medicaid's a little bit different than, traditional estate planning. It's long-term care is a whole nother thing. But I think that's what they mean when they're saying safe harbor trust. If the question is more about like, creditors or other things, other states have that. But in general, one of the biggest protections we help people from are care costs, or kind of protecting their loved ones from creditors and other things. So I haven't got that question before. I hope it was a good answer for what you needed. Are there any other questions? I'll just give it a minute. Okay, that's fine. So just to jump back on the idea of like wills versus trusts and how you can best to alleviate stress. Ultimately, the decision between a will versus trust is not necessarily how much money you have, it's the goals that you have. But what you really need to make sure is that you have, good powers of attorney, and that you have, some sort of plan and it's kind of properly coordinated. Did you mean, okay, I got another question. Did you mean that a trust eliminates probate? Yes. So trust, the benefit of a trust can be that it's outside of the probate process. So probate is a public court process that helps to make sure that your will is followed and everything. A trust often has a private administration where there's no court proceeding required. So your trustee is the person who goes ahead and makes sure that your bills, final expenses, taxes are all paid, and then money goes out to the people that you had designated. So it happens outside of that process, can eliminate that need for probate, which is typically why it takes less time and can overall, cost less money. Where you're looking at that like year to a year and a half with probate, typically with trust, you're going to be looking at more like 6 to 8 months, start to finish. And then with wills, you have that 3 to 5% fee. Trust administration, you're going to find more commonly 1% or often a little under 1%. So, and then I see another question here. I think the reason questions are not coming through chat is disabled. Yes, yeah. So you click on the Q&A question there if you have any questions. So we don't have the chat. We just have the ability to be able to ask questions, and then I kind of answer them live if you're attending here. So, okay. Well, I'm very happy to be having some questions. So sometimes I feel like I really enjoy answering questions and talking back with what it is you'd like to know. I'll give it another minute. So. Okay, well, I'll keep talking. Feel free to ask questions there if you have any. With your estate plan, whether you use a will or a trust, the importance of having the plan is so that way if anything happens to you, that your family has what they need to make sure you're taken care of, and ultimately your estate is going where you wanted it to go when you pass. I see a question now. Should a person have a will and a trust? Definitely. So with all of our trust plans, we still have our clients sign what are considered pour over wills. So an idea with a trust is that it's kind of like a contract you're entering into with yourself as to how you want your estate plan to be handled, both while you're alive and when you pass. In order for a trust to have control of an item, it has to either own that item now or own that item when you pass away. So properly funding your trust is a big part of making sure that it works. Either your trust is the owner right now, which like on a revocable living trust, you'd have most things in there. Irrevocable trust, it depends. But the idea is you have that thing in the trust, so that way it's already there when you pass away. There's no need to move it over. Beneficiary designations appointed to the trust. You still have a will because in case anything was unfunded to your trust. So I always prepare for my clients a set of instructions saying that, going forward, this is how you should maintain your trust, especially if you get new assets, how to title it, how to handle it, call with questions, that sort of thing. But the idea is we want to make sure that at the end of the day, if you had an asset that was outside of your trust, we have the ability to get it back into your trust. So for example, if you did open or had a new asset and you forgot to put it in the name of the trust, say you just bought a house, forgot to put it in the name of your trust or something like that, your will would ultimately say, hey, if anything happens to go through probate, my plan is my trust, get it back into my trust. Now, obviously, we want to make sure your trust is fully funded, so that way there's no reason to have a little bit more of an ineffective estate administration, because we don't want to have a trust administration and a probate necessarily. We want to make sure everything is in the trust, but that's why you want to make sure that your trust is fully funded, so that way it controls everything, because even having that pour over will, if you needed to use it, it has to go through the probate process first. At the end of the day, we're able to still get it into the trust and follow the terms of the trust. But that's why the funding of your trust is really so important, because your trust only controls what it owns or owns when you pass. So you still have the will as kind of an ultimate safety net. A fully funded trust just means that everything that you own is coordinated to your trust, right? It's using that funnel. So for example, with a revocable living trust, if you're your own trustee, then you put a lot of things potentially into that trust, like your home owned by the trust, your bank accounts owned by the trust. Because if you're your own trustee, really, other than the name on that trust, you're not going to notice too much of a difference in how you manage things. It just makes sure that that item is already owned by the trust. So that way, if you pass away, there's no need for that item to go through probate. It's already there. Now, some items can't necessarily be owned by the trust. Best things to think about would be like retirement accounts. If you have qualified funds, you want those to stay qualified funds, and a trust is not a person. So with your retirement accounts, what you would do then is if you have a spouse, they're still your primary beneficiaries. That way they can do a rollover. But typically with revocable trust, it's your spouse first and then your trust second. So that way, if your spouse had passed away before you or you passed at the same time, it's using that trust planning to get it out to who you wanted to. So it's just changing around kind of your ownership or beneficiary designations. So that way your trust actually controls that asset and there's no need for it to go through probate. So that's a good question. And that's actually one of the things on our handout that you guys will be getting. That top 9 estate planning myths talks exactly about making sure that your trusts are funded. That is part of what we do with all of our plans, make sure that our trusts are funded. Okay. Are there any other questions? Okay. Are IRAs included in the unable to be owned by trust category? Yes. So retirement accounts, qualified funds, IRAs, 401ks, Roth IRAs, 403bs, all those things are owned by you as an individual. That's how they get their good, pre-tax or post-tax status. So we don't want to necessarily put that into the trust, because that could be viewed as a complete liquidation of whatever's in that retirement account. We still want to make sure that your trust is looped in on what happens with that retirement account asset. So in the example of a revocable living trust with a married couple, your spouse is still your primary. That way they could do a regular rollover. But if you didn't have a spouse and wanted that retirement account to be doing these other things, that's why the secondary beneficiary on your retirement accounts would be your trust. So, and I mentioned divorce and trust. Absolutely. So obviously, I'm assuming you're mainly protecting like children from divorce if they were to get divorced, and protecting their inheritance. Very common thing that I talk about with clients. Inheritance in Wisconsin is individual property. The problem is that people receive inheritance and they go and put it in a joint account or spend it on a joint thing or pay off that joint debt, whatever it is. And then that can potentially make the entire thing considered marital and then subject to that, division upon divorce or separation. So Sometimes what can be important is maintaining kind of like a separate thing for that child. So what it would be is like your trust would create a trust for that child. And then that trust that for that child, it's their own thing. And you could decide if that child can spend it and manage it and invest it however they want to, but you can still protect it from the more negative things like divorce, creditors, bankruptcy, long-term care. So with that child, they receive their inheritance in their own trust that your trust created, and they can go and open bank accounts, investment accounts, bonds if they wanted to, whatever they really want to, and still have kind of full use of that inheritance. Now they can take some things out if they wanted to, but that doesn't entirely make the entire corpus of that trust then available for that division upon divorce. So you're able to have your child maintain their inheritance in a separate thing, which is what helps it from being considered marital if a divorce was to happen. So that's one of the things that we're, kind of, ask you about. What do you think about your sons and daughters-in-laws and all those good things? And then I see another question. What if both marriage partners would like the home, monies, etc., to go to the kids and don't want the courts to liquidate everything? So it depends on how much money and stuff you're talking about. A couple different ways. So take a specific home that you would like to leave to someone. Say that you want to leave it to one child in particular. Now you have to decide, are you just leaving that asset to that child, or are you having it kind of subject to the division among multiple kids, and then they just take that asset as part of that? Because there's a difference in just leaving that item to that child in addition to like their share of a percentage on everything else versus maybe including that asset in their share of the division of the whole. So take an example. You have two kids. One of them really wants the house. You could leave the house just to that child who wanted it, or potentially as part of that child's half. So you have options there. The court is not necessarily liquidating everything. There's a lot of flexibility for your personal representative, or if you're outside of the court process, the trustee, to follow your wishes. So you just have to decide what it is that you're wanting for that property, how you want it to be part of kind of that math. So that way you're understanding, because you don't want to unintentionally be leaving your child the whole value of that property and half, unless you want to do that, which is fine. But you want to make sure that you're understanding how that kind of equalizes your kids among each other, if that's your intent. So it's not that courts are necessarily liquidating everything. Your child could potentially decide to take a specific item as part of their share, but I specifically like to write that into my planning if that's a concern. That way we're encapsulating your intent for that person to be able to take that item, either as a separate thing, as part of their share, or doing some sort of like purchase, like if you don't have enough assets to cover it, negotiating like a purchase with a promissory note. So sorry that can get a really complicated question. It's a great thing to work with a planner on, so that way you're understanding. Hopefully that answered, at least for right now, your question. And I see another question here. I want my adult kids to decide if they want to keep my duplex as an income source or sell it upon my death. Can this be designated in the trust or as stated in the will? So I mean that's completely up to your kids. The good news is if your kids are going to be those trustees, that is exactly something I would we could write it in. You could also have a good conversation with them, because you writing it in is ultimately a very similar impact to how it would be decided upon dissolution, which separation of everything, not really dissolution. If your kids are having half, they can either decide that they each take half of the property, and that allows them to maintain that income. One of them takes the property as part of their share, or if they sell it and split the proceeds. That's actually something your trustee could just potentially decide at the time. Now you can have co-trustees if you wanted kind of both kids involved on that decision making. That could be an option, only if they really work together though. You don't want too much buddy of heads. So that is definitely something that could be written in, make your trustee aware of it. But if it sounds like you want to give them ultimate discretion over what happens, that's very similar to what a trustee's job is in the first place. Their job is to make sure that everything comes together, bills and final expenses are paid, and then it goes out in whatever kind of shares, percentages, fractions that you have. So ultimately, if they decide to split the property in half, that's just part of that. Okay, I do see I'm kind of out of time here. We only had you guys for half an hour, so I don't mean to take up too much more of your time. Definitely some really good questions today. If you have other questions, you can always shoot us an email at learn more at estateplanninglive.com, I believe is the email there. If you have any questions, otherwise you'll be sent some materials from our webinar today. So you can go ahead and get signed up for that initial consult, have us reach out to you if you would like to. As for our upcoming events and kind of future topics, next week we're talking about estate planning 101, the must-have tools to protect your loved ones. So that's a really good topic. And it's just corrected, the email there is learnmore@hooperlawoffice.com. So sorry, learnmore@hooperlawoffice.com if you want emailed questions. The second week of October, that's when we're going to be talking about guardianship and the alternatives to guardianship. So if you have any questions on that, I know I alluded to it today. I'll talk about that in more detail. And then that third week of October, we're actually going to be doing our Wills versus Trust seminar at the Culver Family Welcome Center in Oshkosh. It's a great seminar talking more about the distinction between wills versus trust, a little bit on long-term care if you have questions there. Otherwise, you can always go to estateplanninglive.com to see a full list of our events, register for anything. You do have to register for that Wills versus Trust seminar. We do have limited seating available, so if you want to attend that, make sure you register. I'll also be giving out some books and other fun materials there. So, okay, well, thank you all so much for your time. Again, you had great questions today. You need anything, you can email learnmore@hooperlawoffice.com, sign up for that initial consult, or attend any of our other kind of upcoming educational things. So, all right, have a good rest